evening. Last time, actually last Monday, we have already embarked on the discussion of easement, and we've just gone through the 4 characteristics of easement, and then we come to some other features which would help us to know whether certain rights claimed by a claimant should amount to easement or not. And we have seen 2 examples of a claim to use certain land, the servient tenement, as a car park, whether such claim or such rights could amount to an easement. So in general, if you are talking about you have to use the land, the servient tenement, you use a particular area and use it all the time, then it would amount to joint user, and that is not an easement, because the easement could not, the holder of the easement could not jointly use certain land with the owner of the servient tenement. But if you are just using a big piece of land as car park, and you are not parking the car at the same spot all the time, and then that right to use that servient tenement for car parking is capable of becoming an easement. And now we are looking at 3rd example about using easement as car park. Now, I say using easement as car park because here we have an example in which there was a driveway between 2 buildings. Okay, it's a plaintiff building, defendant's building here, and this particular driveway is divided into 3 portions, A, B, C. Now, I can't remember exactly, but anyway, one owner owns AC and the other owner owns B. I can't remember exactly. It is the plaintiff or defendant, but that was the interesting, situation. Or defendants, exactly. Defendant is owner of B, which is in the middle of A and C. Now, in order that everyone can make use of this driveway, therefore the plaintiff and defendant grant to each other easement. So DP, plaintiff, grant an easement to defendant, owner of B, a right of way to use A and C. Likewise, D grants a right of way for P to use part B, so that it is a pathway which you can go through without any difficulty. Now, and so they execute a deed. Remember why a deed is necessary? Because you want to grant or create a legal estate, you need a deed. So they use a deed to grant each other the right of way in relation to these 3 portions. And in the very beginning, 1981, when this deed was created, actually P, the owner of this building, did not really need this driveway that much. So it was always D who was in control of this driveway, because D need to use this driveway very much, and actually not only as a driveway but also as a car park. So he parked the car there on this driveway and allowed his visitors to park car there. And of course, it was the present owner is different from the grantor who grant the right of way to each other. But in any event, in the past, because the plaintiff did not, I should not use plaintiff, the owner on this part did not really need the driveway that much. An employee of that owner actually has promised orally to defendant, but as long as you need to use this driveway, use it as you like. Well, you can use it as a car park, no problem. We don't need that, you know. But now, the owner of this part need this driveway as a real driveway. He has vehicles to go through, and the cars parked on this driveway has created obstruction to visitor and the company cars of the plaintiff. Therefore, he wants the defendant to take the car away. Well, temporary parking okay, but you cannot park it all the time. And the defendant said, well, first of all, we have this grant of easement, and then the previous employee has promised that we can use it as a car park. And now, if you have studied civil procedure, you should know what is an interlocutory injunction. That means the plaintiff goes to court to apply for an order of injunction, and basically he wants to stop the defendant to do something. In this case, to stop the defendant to use the driveway as car park. But if you have to wait until the hearing of the entire case, it may take quite a while. So they want an immediate order from the court. So it's called interlocutory. That is before the hearing of that litigation really takes place. And he wants the interlocutory injunction to restrain the defendant until the day of judgment or other order from pausing or permitting cars to be parked on the driveway. Now, when this hearing was heard, the judge, Justice Wong, refused to grant interlocutory injunction. And of course, it is not that easy in this particular case because usually the court will favor the status quo. That means what was the situation at present or at the time the interlocutory application was made. Since defendant has been using the driveway as car park for so many years, so that was the status, what we call the status quo. And it is court is rather reluctant to disturb the status quo until a full hearing. So that application was refused, and the defendant, however, appealed. Now, in fact, the appeal was allowed by the Court of Appeal, and Godfrey, Justice of Appeal, was the judge who delivered the judgment of the court. He said the owner of the dominant tenement has no absolute right to use each and every portion of the right of way. Now, because when we say an easement, we said it must be a very defined and kind of precise rights in relation to the servient tenement, because the servient tenement does not belong to the holder of the easement. So the owner of the dominant tenement was entitled to complain only of substantial interference that the right given by the owner of the servient tenement. Now, the rights given by the servient tenement, here, the plaintiff, was a right of way, but not a car park. They are the owner of the servient tenement. Of course, they should be entitled to use his own land for whatever purposes he like, subject to, this easement. That means there should not be any substantial interference with the use of the easement. And in this case, the court, when considering interlocutory injunction, we usually would preserve the status quo, but the court would also take into account what we call the balance of convenience. That is to say, when the court weighs the pros and cons of each party, you will see they will see, well, which particular side, defendant or plaintiff, should be in the favor of this balance of convenience before they would make such an interlocutory order. And the court said, now, you only got an easement by the deed, but you actually, defendant talking about, substantially interfere with the plaintiff's right of way. You use it as a driveway, they cannot use that driveway as a right of way. So the balance of convenience came down in favor of the plaintiff, even though the stated quo was that the driveway had been used by the defendant as car park. So again, this case just reinforced the ratio of the two previous cases. Now, if you want to use a right of way as car park, that means the owner of the dominant tenement could not use it, and that would be not consistent with the concept of right of way. Now, if you want to drive through, okay, but you are not driving through. You are stopping the car there, parking the car there. Therefore, in this particular case, the court once again reinforced the concept of whether you can claim a right of, an easement for parking car. If it amounts to joint user or even exclusive possession, then you can never claim that such right amounts to an easement. But just like the case in which the owner of the dominant tenement can park anywhere in the big forecourt of the buildings, and he did not actually park the car there all the time. Well, that could be amount to an easement, but not exclusive possession or joint user. Now, we come to a more difficult, in fact, it's difficult because this case actually decided contrary to the line of cases about easement, that easement could not be equivalent to exclusive possession. But it was decided in a very special factual matrix. Okay, first of all, plaintiff and defendants were neighbors. No, this is the first case. This is the normal one. The next one coming up will be different. The defendant claimed a right to store articles in a cellar beneath the plaintiff's drawing room floor. Now, he said, well, he got an easement to store articles in a cellar beneath the plaintiff's drawing room floor. And this particular claim was rejected by Justice Brightman. He refused to recognize this right to store articles in a cellar amount to an easement, because if you store things there, you actually are claiming exclusive possession of the use of that cellar. So exclusive possession is also not equivalent to an easement. Exclusive possession is a characteristic of a lease, right? But yeah, this is the naughty case that I am just referring to. The court upheld an easement to store coal in a landlord's coal shed, despite the right amount to an exclusive use of the coal shed. Now, this is one problem with this case, and this case also creates another problem. We'll come to it a little bit later. Now, the facts of the case is this. First of all, defendant let a top floor flat of a house which the defendant owns to Mrs. Wright in 1940. It, at the very beginning, has nothing to do with the coal shed. It is just a lease for a top floor flat. Now, 1 year later, Mrs. Wright complained that she did not have enough space to store coals, and the weather was very cold in winter. So the defendant, the landlord, grants Mrs. Wright a permission, which means a license to use the shed, the coal shed in the garden. Of course, the garden belonged to the defendant for the storage of the coal, and this permission was exercised. That means Mrs. Wright actually make use of the shed to store her coals. Now, so the coal shed becomes the servient tenement. Now, 2 years later, the tenancy expire, the old tenancy expire, and the defendant wants a new tenancy of that top floor, and not just the top floor, but there was additional rooms to Mrs. Wright and her daughter, and that's why she need an additional room. And in this particular tenancy agreement, there was no direct reference made to the use of the coal shed. But as a matter of fact, as a matter of practice, Mrs. Wright and her daughters still enjoy the use of the coal shed until 4 years later. The defendant, the landlord, said, well, you have been using my coal shed for so many years. Well, you should start to pay some storage fees. All along I gave you the permission to store coal there for free, but now I want to charge you for fees, which, well, on the face of it, proper for the landlord to do so, because she is the landlord is the landlord of the coal shed. But Mrs. Wright and her daughter said, well, we have been using that for so many years, 6 years altogether, going back to 41. Without any charge. It's unfair that you charge us. And they also claim that they have acquired an easement to use that coal shed to store coal. And they brought an action, they sued, to restrain the interference of the landlord. Interference what? Interference with their use of the shed on the ground. Is that they already got an easement to make use of that whole shed. Now, if we go back to this previous case, the load ratio is very clear. Mrs. Wright are doomed to fail because they are actually claiming for exclusive possession of that coal shed. But the defendant makes things complicated. Before the hearing was heard by the court, they just tear down or pull down the coal shed altogether. You cannot use it, And when the hearing took place in court, and when this fact that the defendant has pulled down the coal shed was made known to the court was very angry because this is a subject matter of litigation. It is not up. Of course, they are the landlord in a way. They have the rights to pull it down, but we are still disputing whether an easement exists or not. You should wait until the court make a decision. And the court, after hearing, held that Mrs. Wright and her daughter's rights to use the shed amounted to an easement, which was, completely a surprise for the litigants as well as to we lawyers. But the court goes on to say that since the shed was already pulled down, the court is not going to make an order that the shed should be rebuilt. Instead, the court grants damages or award damages to Mrs. Wright. Now, this is a controversial decision, but it still represents good laws in Hong Kong. And the effect of this case is, first of all, a personal right, a license. Remember in 1941, it was only a license granted by the landlord to Mrs. Wright to use the shed for storing coal. But this license to use property A, that is the coal shed, the potential servient tenement, because when the license is granted, there was no easement, so there was no servient tenement. It's only potentially a servient tenement. Attached to property B, that is the potential dominant tenement. In this particular case, it is the top floor where Mrs. Wright rent. And this may become a proprietary right. The license may be upgraded, under quotation mark, to an easement when the lease of that property B, that is the top floor, is renewed, so that property B becomes the dominant tenement of the easement created, and property A, in our case, the coal shed, becomes the servient tenement. And that is the ratio of Wright and McAdam. And that becomes one way to acquire an easement, which was unheard of before this case was decided. Now, another controversial point is that the exclusive use of the codeshare should not have amount to an easement. We have a previous decision in which the court said, exclusive use of the seller for storing articles could not be an easement because you are talking about exclusive possession. But apparently the court just ignored this point, and lawyer tried to explain why the court come to such a conclusion. They said, it is because the defendant dismantled or pulled down the ship altogether before the trial. The court upheld such an exclusive use as easement simply to punish, under quotation mark, the defendant for having preempted the court. Well, whether this is the real reason behind the decision of the court, we can never be found out. But that is the case, and it has been followed in Hong Kong. Now we come to a new topic about easement. We just learned from this writer McAdam, you can acquire an easement in such a peculiar way, and license can become an easement on the renewal of a lease. Now, other than this particular or very peculiar way to acquire an easement, there are three ways to acquire an easement: express easement, implied easement, and presumed easement. The express easement is very straightforward, just like the case Lee type property. I am an owner of the servient tenement. I grant you an easement. Okay, you can use my driveway as a driveway. Just go through A and C, no problem. I create a deed to create a legal easement for you. This is by grant. By statute. Now, of course, that is particularly in our context, it has to do with conveyancing. When you purchase a property as a purchaser, the vendor, the previous owner, would have to assign the title of that property to you. Again, he has to use a deed. The assignment is a deed. And under section, later on you'll learn that in the part of conveyancing, 16 of CPO, if this particular land has already an easement attached, they would be assigned to you as purchaser under that section. So this is a statutory grant or expressed easement. Or by reservation. Reservation is when the owner, the owner of this servient tenement sell the servient tenement to you, and he would expressly say that I will reserve a right to use your land as servient tenement for certain purposes, for example, right of way. Now, but in practice, how can this so-called grant and reservation be effective? Now again, by looking at the diagram, it would be easier to understand. Okay, since we have, whenever we deal with easement, we have two tenements, the dominant and the servient tenement. Now to begin with, okay, call it A, lot A and lot B. Say, for example, this is owned by owner, both lot A and lot B. Now, grant. When owner sell lot A to purchaser, purchaser said, well, say for example the highway is here. Well, lot A is far from the highway, and it may not be easy for me to go to the highway. Can you reduce the price? And the owner said, oh, forget it. I'll grant you right away. That is grant. Reserve. This time we are talking about selling lot B to purchaser. And owner said, well, since I am keeping lot A, I will reserve a right of way for lot A. So when purchaser get lot B, this lot B becomes a servient tenement, subject to this right of way enjoyed by lot A. So reserve and granted is operated in such a way. Now I use so-called black acre, etc., but it would be very easy to understand by looking at the picture. And of course, whether there is a grant or reservation depends on the true construction of the word being used. Now, when we talk about expressed easement, in most cases, there is a deed for granting or reserving the easement. But experience told us that even such deed was drafted by lawyers. In fact, 10 or 20 years later, when we read the deed, it is not always clear what exact rights was being granted or reserved. Yeah, they will say a easement, a right of way, but to what extent that right of way is about, experience told us that the lawyers in the old days are very sloppish. Now, look at this particular case, TLC Trade Land Company and Samuel and Company. This case was heard in 2005, and the question for the court in that case is whether the grant of the right of way include the right of vehicular access or just pedestrian use. When you say, now I give you a right of way here, are you talking about you only allow human being walking through your land, or you allow me to drive with my private car, and sometimes allow me to, to use trucks to go through your land? When the draftman create the deed, they did not say it clearly. So at the end, such dispute has to be settled by the court. Now, look at that is the verbatim reproduction of that deed. All rights of way, but what are the rights of way? And other rights in connection with the said premises as shown on the said plan and color yellow. So you have a plan of that right of way with color, but still we don't know what the rights of way is about, and should be used and enjoyed in common by the first co-owner and second co-owners and their or his respective tenant, servant, and workman. Now this is the typical way of legal document in the past. No punctuation in between. Okay, and other person authorized by them to go past and be passed over, and upon pass and repass. Okay, we understand you can go through, but is it confined to human being walking on that right way or vehicular access? No such expressed reference is made here. So pass over and upon the portions of the said premises, and they hereby agree between the parties that no other obstacle shall be allowed to be placed on the said right of way, nor shall any car be parked, thereupon. Yeah, you cannot park the car there, but do you allow car to go through? It's not clear, right? And the court of first instance in that case held that such grant includes a right of vehicular access. And one of the ground is that, first of all rights of way. When you say all rights of way, so it should include vehicular access. And also they take into account the vicinity of that piece of land to see whether people has been using vehicles to get access to the land and come to the conclusion. Now, another example, again decided by the Hong Kong Court of Appeal. Question is whether the right-of-way granted in an industrial area refer to a vehicular access or not. Now, and in that case, there was no all rights of way. So the court has to take into account the surrounding, and the vicinity of the land to make a judgment whether vehicular access was intended, even though it is not expressly sounded out. And the Court of Appeal said that the right way in this particular case was granted in 1970. I think many of you were not born yet, so you would not know what would be the situation in 1970. That was the time in which industrial activities in Hong Kong was very, very proliferate. And the right way to pass and repass the road, therefore the court said, well, we are talking about an industrial development area. And in those days, industrial area there would be many factories of all kinds of goods, would make use of those industrial buildings. And of course, they would need vehicles, trucks, to transport the manufactured product to the to different places, particularly to the containers for sending to overseas. So Court of Appeal said that given the context of the grant, that particular area, that particular right way should include a vehicular access. So we can see, even though you have an expressed grant, it may not be that straightforward to know what exact right is being granted. Now, Section 16, I have already mentioned. 16 subsection 1 CPO, unless a contrary intention is expressed in an assignment shall operate to assign with the land all rights, interests, privileges, easement. Okay, so if that land is enjoying any easement, when this land is assigned to you as the purchaser, then the easement will also go with the land to you. this section would automatically transfer all easement to the new assignee. And of course, you cannot forget this particular case in which the Court of Appeal, English Court of Appeal, held that permission, a license given by a landlord to his tenant to store coal in the garden became a legal easement of storage when the lease was renewed. And in fact, in that case, if you look at the real judgment, you will see that the Court of Appeal actually also tried to make use of an equivalent section of Section 16(1) to build up the argument that such upgrading was possible. But it's not really that important for us to go into the detail. But basically, we just learned about this particular features of the so-called possibility of upgrading the license to a legal easement. Sometimes you will come across this term, quasi-easement. Quasi-easement usually refer to, just like an example here. That was before the purchase. Owner owns both dominant and servient tenement, and he has been using the servient tenement for the benefit of the dominant tenement. But it could not be an easement because one of the characteristics for easement is the two land must be occupied or owned by different owners or different person. And since the owner is still occupying both, we call that a quasi-easement. And these are the situations whereby the license or quasi-easement could be upgraded to a legal easement or renewal of the lease. First of all, the two tenements must be owned by the same person. And the two tenements were occupied by different persons before the assignment or before the lease, or this is first situation. The other situation is where the two tenements were occupied by the same person. The use of the quasi-easement was continuous and apparent and reasonably necessary for the use and enjoyment of the land. So that is, in this particular case, when owner was staying in Lot A, he has always been using this pathway to go to the outside world, but it's continuous and apparent. And it is reasonably necessary because all these other parts are surrounded by trees and mountains. It would take huge effort to get around Lot B to go to the highway, so it is using this particular pathway would be necessary. Okay, so that is expressed easement. Implied easement. Implied easement. Now, for exam purposes, this is a more important topic than the expressed easement. Particularly, there are three ways that an easement can be implied. The last one, by the rule, Wheeldon and Burroughs. It has been asked in exam many, many times. Now, how can an easement be implied? By necessity, by common intention, and by the rules in Wheeldon and Burroughs. Now, by necessity, that would be rather easy to understand in practice. Now, again, it usually happens when we have the similar situation whereby the owner owns two pieces of land or two tenements, Lot A, Lot B. The easiest way to explain this concept of easement by necessity is when one of the lot, the dominant tenement, is what we call landlocked. It was being locked by other land. But owner sell lot A to the purchaser. How can purchaser go to the outside world without going through lot B? So when he sells this lot A to purchaser, impliedly he is also granting a right of way for purchaser to go to the outside world. That is implied easement. Now, of course, it must be necessary. It must be necessity, the word necessity. If the purchaser had alternative ways, right of ways, no matter how inconvenient they may be, there could not be an easement by necessity. And in fact, we have a classic case of that, in which, the court refused or denied claimant's claim for a right of way on the ground that his land was not completely landlocked. He still have an access to the highway, even though the access was down a 20-foot embankment. So you must be completely landlocked. Otherwise, it is not easy to get an implied easement. And in a rather recent case, the court said that this doctrine of so-called implied easement by necessity is actually built on the presumed intention of the parties, but not on public policy. It's not because as a matter of policy, you cannot sell a piece of land completely landlocked to a purchaser. Now, if the purchaser knows in advance lot A is completely surrounded by lot B, and the owner will not give him or her a right of way, yet he still purchased lot A, then it is his problem. He cannot claim implied easement. The so-called presumed intention would be, well, in a normal course of business, when the right of way was not really mentioned between these two parties, because just like the implied term, the officious bystanders test, someone standing next to the two person asking, well, if you're purchasing lot A, will you get a right of way from lot B? Both the landowner and purchaser will say, of course, there was this. So it is really a presumed intention. Both the owner and purchaser do have an intention that a right of way will be granted. Then we would have this doctrine of by necessity. But if the assignment expressly states there was no right of way implied, then you would have no right of way implied. And implied easement by common intention, again, it would be the case whereby parties to the purchase of a piece of land, sale and purchase of a piece of land, has commonly agreed, mutually agreed, that a right of way will be given to the purchaser. So such easement may be necessary to give effect to the common intention of parties, to a grant of real property with reference to a manner of purposes in and for which the land granted to be used. And again, because it is an easement, so it is essential that the subject of the grant, that is the easement, should be used in some defined and particular manner. And it's not enough that the subject of the grant should be intended to be used in a manner which may or may not involve this definite and particular use again. Even though we are talking about implied easement, it has to fit all the characteristics of an easement. Now, classic example of implied easement by common intention. Now, this is a case in which we have a building owned by one owner, the entire building owned by him. And in the ground floor, the owner grants a long lease to a tenant. And in the lease itself, it is expressly said that the tenant is going to run a restaurant on the ground floor. Now, after the lease has gone for a while, the tenant did not want to continue with the lease. So he sold the lease, the residue of the lease, to a Mr. Wong. I don't know whether he comes from Hong Kong or not. But anyway, he is a chef of Chinese food. He used this ground floor to run a Chinese restaurant. Successful one, actually. But Chinese cooking, smoke, oil, sound, etc. And particularly, the smoke and smell were coming out from the restaurant and go to the upper floor, etc. And it was against the regulations. And they got warning from the relevant department saying that you must have some ducts to guide the smell to the top of the building, so that people using the second floor, occupying second floor, would not be disturbed. And Mr. Wong then asked the landlord, okay, we are going to make use of the outer wall of the second floor. Then it is the servient tenement, for the purpose of building the ventilation duct. But the owner said, no, we never expect that ventilation duct will be built on the wall. No, you think of your own, you solve your own problem. But in that case, Mr. Wong sued the landlord for this right to build the ventilation duct on the wall, based upon implied easement. He said that, since you are granting this ground floor for the tenant to run a restaurant, you cannot derogate from your grant. You must allow the owner of the restaurant to comply with all those hygiene regulations. So Mr. Wong must have an implied right to build ventilation duct along the second floor as a kind of easement. And in fact, the judge granted the declaration or in favor of Mr. Wong. And the landlord appealed, but Court of Appeal affirmed the judge and held that the plaintiff, Mr. Wong, was entitled to an easement of a right to flow of air through the ventilation duct by an easement of necessity. Because it would have been impossible for the lessee to carry on his business of a restaurant in the absence of such rights. And it is also by common intention, because the landlord grant for the tenant to run a restaurant. So this is a commonly intended that ground floor has to be used as a restaurant. Against those two way to get the implied easement is straightforward. The more difficult one is this one, asked in exam for many times. Wheeldon and barrel. Now, this particular case deal with implied easement, and the legal principle is based upon the maxim, in fact similar to the landlord has an implied obligation not to derogate from his grant. It comes from the same concept. A grantor may not derogate from his grant. If you grant something to the grantee, you cannot do anything to prevent the grantee to use or to enjoy the grant you gave him or her. It means the owner cannot grant land to another on such term that the grantee receive less than he was promised. Now, again, it is a situation quite similar to what we have described earlier. Again, we start off with a big piece of land, and it is divided into two lots, owned by the same owner. Now, there is Mr. Tapley. Now, he sold this part to, one of our protagonists in that case, Wheeldon, Mr. Wheeldon. And later on, sell this part to Barrows. And on this part, there was somehow a structure, and there were some windows on that structure. If someone climb up to this structure and look through the window, they can see everything on Wheeldon's land. Now, Mr. Wheeldon died, and the property was passed to her widow, Mrs. Wheeldon. So we still have Wheeldon as the party. And Mrs. Wheeldon disliked this structure. He built some hoardings along the boundary, of course, within her own land, to block the view of this structure. And defendant said that, well, this is not just a structure, but we have an easement of view through the windows. Remember, you cannot have an easement of view if it's general. But if you're talking about some view through a definite aperture, definite holes or opening, then it could amount to an easement. So, and I think this is a bit drastic, He just locked down the hoardings altogether, saying that, well, you build this hoarding are interfering with my easement. But the Court of Appeal held that defendant has no right to lock down the hoardings because when the land was sold to Mr. Wildon, Kelly, the original owner, did not reserve a right to light through the windows of the shed. That is the fact of the case. Nothing really unusual. But the important thing is about the legal reasoning discussed in the case, which give us this particular concept of implied easement by the rule of Wildon and Barrow. Lord Justice Thesiger said, on the grant by the owner of a tenement, or it should be or, I'm sorry, the owner of a tenement or a part of that tenement, as it is, then use and enjoy, there will pass to the grantee all those continuous and apparent easements, by which, of course, I mean quasi-easements, or, in other words, all those easements which are necessary to the reasonable enjoyment of the property granted, and which have been and are at the time of the grant being used by the owners of the entirety for the benefit of the part granted. Now, so they are actually talking about the same thing as I said a little bit earlier. Imagine we have these two pieces of land owned by the same owner. Lot A, Lot B. When owner occupied Lot A or stay on Lot A, he always used Lot B, a pathway of Lot B to go to the highway. And when he sells Lot A to purchaser, this right of using this pathway, which is a quasi-easement, because at that time, both Lot A and Lot B were owned by owner. But when Lot A is sold to purchaser, it becomes two separate tenements. And this right, continuous and apparent right, quasi-easement, would be converted into an easement proper. So basically it means this. A grantor cannot deviate from his grant. It means because when you are using Lot A, you are enjoying this pathway as easement. When you sell Lot A to purchaser, you should also sell all the rights as you enjoy when you occupy Lot A. You cannot say, well, of course they can do it expressly, but if you do not spell it out that you do not pass this easement to owner of Lot A, then the right should be implied. So that is actually what easement by implication under the rule of Wildon and Barrow means, and it actually has become the statutory way of obtaining an easement under Section 16(1). They are talking about the same thing, the same concept, only that under the case of Wildon and Barrow, under Section 16, we are only confined to the assignment, the effect of the assignment. But here, wheeled on and barrels, even some right is not expressly attached to an assignment, because in this, when even owner assign lot A under the assignment to purchaser, this rights could not be passed to purchaser under section 16(1) because it was not an easement before lot A was sold to purchaser. We still need wheeled on and barrel to pass this particular quasi-easement to the purchaser. So this is what I put in words for what I have just explained. An owner has been using one part of his land in a particular manner, such as causing part A as access to the highway to another part B. His practice of causing part A is described as a quasi-easement, because an owner cannot have an easement over his own land. If the owner later sells part B, then such quasi-easement as existing at the time of the sale on part A may, by implication, become easement proper in favor of part B. Now, the concept is that straightforward, but for exam, you have to remember all this, unfortunately. So you must say, acquisition of easement by implication under the rules of wheeled on and barrel. There are 3 requirements under this rule. Even you don't understand, you have to remember them for exam purposes. But I think but in any event, it's not really difficult to understand. Quasi-easement must be continuous and apparent, and it must be necessary to the reasonable enjoyment of property grant. Now, all these words are, similar to the words under section 16(1), and it must have been at the time of the grant used by the grantor for the benefit of the part of the land granted. And the rule in this wheeled on and barrel can be implied in co-owned land in certain circumstances. Remember, if we are talking about co-owned land, then because all the owner own every part of the land, it could not be an easement. But the law nowadays recognize that such rights could exist, not in the form of easement, but in the form of quasi-easement. And this is a recent case, Chen Oyuk, in which the court said that despite easement could not exist in co-owned land, they are actually talking about multi-story building in this case. Quasi-easement formed under the principle of wheeled on and barrel can be implied as a matter of law or as a matter of business efficacy in the DMC as contractual quasi-easement amongst the owners. In other words, if there is anything similar in a multi-story building, but this time we are talking about flat A and flat B, for example, it could still amount to a quasi-easement. And the occupier of Unit A may have the right to make use of course, it's impossible if we are talking about unit to go into the unit, but maybe to make use of some corridor, leading to lot Unit B. If we are talking about a multi-story buildings situation. That is enough for exam purposes. what we are talking about, acquisition of easement by so-called presumed easement or easement by prescription. Now, as a responsible teacher, I have to put all this in the slide. But well, I more or less can guarantee that you don't need to remember any of this for your exam purposes, because it has never been asked for at least 20 years, since I started teaching this program, because it is more complicated and and the law is still evolving. Now, but generally, let's give you a concept of this so-called easement by prescription. The idea is similar to adverse possession. Now, in adverse possession, we say, well, if I occupy a piece of land long enough, under common law, it requires 20 years. But our CPO has already cut it down to 12 years. But under common law, it is still 20 years. If you occupy a piece of land for 20 years without permission of the owner, then you may acquire a title over and above the real owner. Okay, that was the concept of adverse possession. Easement by prescription is similar. If you use the servient tenement in a certain way long enough, you may acquire an easement on that servient tenement by reason of your continuous use. But the law itself, the concept is not difficult, but the law in relation to easement by prescription has been made complicated. One reason is that in England, we do have freehold and leasehold. So they are completely different kind of estate. One has a definite term, but the other is supposed to be lasting forever. And the idea first developed at common law about easement by prescription is that, well, in what we call the time immemorial, you can't remember when. In fact, in some day in history, the owner of the servient tenement actually has granted an easement to the owner of the dominant tenement. But the change of the title of these two pieces of land has happened for so many times in so long period of time. We no longer remember that particular grant. Therefore, but why you can use it for so long? Because that has been granted in history. So the court would recognize that, oh, there was an easement by prescription. So, but first of all, the problem with this concept may be applicable in England, but apparently not in Hong Kong, because first of all, we do not have freehold, and the time immemorial, actually there's a historical years, 1065, something like that. If we are talking about 1065, Hong Kong Island did not belong to England, right? Common law was not applicable to Hong Kong. So all this difficulty involved in the land of Hong Kong make this concept not part of this common law prescription concept, not applicable in Hong Kong. But now 1189, I'm sorry, 1189 time immemorial. Not, for example, this start from 1189. This concept did not apply to Hong Kong. But in England, that concept has been somehow codified by Parliament, English Parliament, in this Prescription Act 1832. And they make things easy. If an easement has been enjoyed for 20 years, it could not be defeated by proof of the use only after 1189. And if you can prove you have been using the Serbian tenement as an easement, use an easement on the Serbian tenement for over 40 years, the easement is deemed to be absolute and indefeasible. Now, you may ask, this is an English law, why it is relevant to Hong Kong? That was because before 1991, we have an ordinance called Application of English Law Ordinance, which was enacted in 1988. It is said that all English law would be applicable in Hong Kong. If there is anything which makes it not applicable, then the court can modify the English law to suit the Hong Kong situation. And this particular case, the case itself is mainly about adverse possession, but the so-called prescription, easement by prescription, was also relevant because their land was somehow landlocked, and they claimed that, you know, they acquire an easement, you know, to go to the public highway. And so they also claimed that they had an easement to make use of that particular road to go to the highway. And, well, there's no need really to go through the detail of this particular case. The most important thing is, you know, the Court of Appeal said that Hong Kong is a very different place than England. First of all, we do not have any freehold. So this concept of prescription would be not applicable, completely meaningless in Hong Kong, you know. Yet, he said, by virtue of this ordinance, the Prescription Act 1832 maybe could be enforceable in Hong Kong, subject to modification. And therefore, there might be prescription by one tenant against another tenant, you know, because as we know, all so-called landowners in Hong Kong are tenants of the same landlord. That is now the state of China PLC must be at least arguable. And you know, so this is the first time Hong Kong court recognized the possibility of prescription, easement by prescription, under this so-called Prescription Act 1832. But the case did not go to trial. So, in fact, there was no authority that this act actually applied in Hong Kong. It's only because at that stage the court is only dealing with whether this is arguable or not. Now, ultimately, the Hong Kong court recognized the third possibility of easement by prescription, laws of modern grant. Again, this is a legal fiction. They said the the common law, it is said that, just like the description that as long as you use the servient tenement for a certain purpose long enough, the court would presume that sometime modern grant, why it's called modern, that is not 1189 anymore, but sometime in the modern era, the owner of the servient tenement has been granted an easement to the owner of the dominant tenement. But that grant, that deed has been lost. Therefore, we can only infer that list from the continuous use of the servient tenement. And, there has been discussion by Justice Reyes, and it was upheld by the Hong Kong Court of Appeal, and ultimately upheld by the Court of Final Appeal. But they are not talking about the same case, but different cases dealing with this particular doctrine of laws of modern grant. So for your purposes, you just remember that acquire easement by prescription under the doctrine of laws of modern grant is recognized in Hong Kong. That's it. Just know about this would be enough for your purpose. In fact, this is some rather complicated law. Even lawyers find it difficult to follow. So, as I said, as a responsible teacher, I have to briefly talk about that. Just look at my slide, read the workbook. If you don't understand, forget about it. Just get the concept. If you use the servient tenement in a particular manner for over 20 years, you may acquire an easement under the doctrine of laws of modern grant. That's it. That would be enough for your exam purposes. Okay, so that is the end of our discussion of easement. We'll also take a 15 minutes break, and after that, we'll start looking at land covenants, which is